This
Meeting
conference will now
to
be
order.
recorded.
Oh, sorry. I now call the Board of Adjustment meeting to order and ask Kelly to please call the roll.
Member Martell?
Here.
Member Zeeb?
Here.
Member Bingham?
Here.
Member Arsali?
Here.
And Chair Hendon.
Present.
Okay, and Member Slow was absent with notice.
Could we now stand for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Selection of chair and vice chair. So there have been a number of additions to our committee, and as such, we're required to have a vote for chair and vice chair of the committee. Do you have ballots?
Yes, I have ballots. I will pass them around. Please mark one of your selection and then put your name at the bottom of who you are. Ballot. Okay, the results are as follows. 1 vote for Sloat, 1 vote for Martell, and 3 votes for Hendon. So, Mr. Hendon, you want to share again? Congratulations.
Thank you. And how about vice chair then?
We've got vice chair ballots here. Same routine. Okay, the votes are as follows. 1 vote for Martell, 1 vote for Zeeb, and 3 votes for Miss Betty Bingham. Congratulations, Miss Betty, our vice chair.
Congratulations, Betty.
The proceedings are now called to order on agenda item number 3, a quasi judicial hearing to consider the administrative variance request for Angel Johnston. Ms. Kelly, can you read the agenda item title?
An application submitted by Angel Darlene Johnson as owner for a parcel of property located at 26 Harbor Drive South, Ocean Ridge, Florida, 33435, requesting a variance from the provisions of the Land Development Code, excuse me, Chapter 64, zoning, Article 3, supplemental regulations, Section 64-41, accessory uses, buildings, and structures generally to permit a sun trellis to be located 7 foot 3 inches from the legal property line. Chapter 64 zoning, Article 1, district regulations 64-1, RSF and RSC single-family residential districts, and Section 64-57, balconies not to exceed into required yard setback. Also from the provisions of the Land Development Code, Chapter 67, building and building regulations, Article 3, technical codes and other construction standards, Section 67-36, balconies not to extend into the required yards to permit the extension of the second floor balcony by 2 feet. The variance would allow for a 23-foot setback for the second floor balcony from the property line and a relief from a 2-foot from 25-foot required setback, and we would allow for a 7-foot 3-inch setback from the sun trellis from the property line and a relief of 17 foot 9 inches from the 25-foot required setback.
Thank you. At this time, any ex parte communication should either be disclosed by identifying the subject of the communication and the identity of the person, group, or entity with whom communication took place, or any correspondence be provided to the town clerk and be made part of the public record. In addition, each member of the board may identify the existence of any investigations or site visits he or she has conducted, or any expert opinions received, and disclose any conflicts of interest on this matter.
I've had no communication at all. I do live 5 houses down from this property, so, but I didn't visit the property. That's as much as I know.
Betty?
I went down to look at the property, both sides again, to see what the effect of this would be on the people in the neighborhood.
Eric?
Purely visual.
I did not have any communications. I did use Google Earth to look at the property.
I had no communication, but I do own a house about 5 houses away from that property.
You two live together.
5 houses apart, either side.
That's not okay.
That was cool.
I have not visited the site this time around, but this is a revisit, so to speak, to the committee.
So if I can speak for a second?
Not yet, thank you. But I had viewed the property previously. I think it was a year ago. We will then proceed with the hearing on this matter. Will the town clerk please swear in the witnesses?
Will anyone wishing to speak on this item please stand and raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
When you are called forward, please state your name and address clearly for the record and whether or not you've been sworn in.
I'm Darlene Johnston. I'm the owner of the property, and this is just a renewal of a variance that expired because Mr. Guy did everything he could to not let this project go forward. And I'm sorry, but I lost my father yesterday. I'm not okay to be here this morning, but I'm here because this means so much to me. Thank you.
The town staff will now make its presentation on this matter.
Good morning, Chair, board members, Corey O'Gorman, Town Planner. As indicated in the staff report, this is a request for 2 variances, one for the sun trellis, one for the balcony. Both were heard by the Board of Adjustment and approved previously. The staff report indicates some of the background and conditions that were the basis for the approval. As Ms. Johnston indicated, there were delays during the permitting that caused the variances to expire. This is essentially a request for reinstatement. The application does provide an outline of special circumstances and conditions. From the applicant's perspective, the staff report also includes analysis of special conditions for the property related to the placement of the building on the site. And the recommendation is to consider the information in the staff report, the application, any testimony that you hear this morning, and make a decision on that basis. And I'm happy to answer any questions that I can. Thank you.
Thank you. Sorry,
May I ask you something in the context of this particular project? May I?
yes.
I'm here, my name is Costa.
Sir,
Yes.
if you're going to speak, you need to be sworn in.
Okay, sure.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name.
My name is Costa Sevakovic. I'm here on behalf of Palm Beach Pergola. I've had the privilege of being in many of these sites, and I have the privilege of being in both the residential and the commercial sites. In terms of the commercial sites, they absolutely are glorious, gorgeous in comparison to everything. One of the commercial sites which was done at Frenchman's Creek was regarded and I guess promoted by Condé Nast as the most beautiful facility in southern Florida. Now, as far as the domestic and residential properties, you have all been to the area, you know the area intimately. May I tell you something? When this pergola goes up, everyone will want to have one. Why? Because it is truly beautiful and it enhances your ability to utilize your yards to the fullest. You and I know that we're here already in the summer in Florida. When we are in the summer in Florida, you're either baking or you're being poured upon, you're being drenched, one or the other. You cannot go outside and enjoy your pool until way back when in the evenings, which is lovely. But during the day, that pool is inaccessible. Your yard is inaccessible. The whole point of being in Florida is inaccessible. These pergolas, these beautiful, beautiful structures, enhance your ability to utilize the property that you so value. The outdoor activity with your family and your friends that you so need and you so desire. We're missing it, guys. All I'm saying is the variances were granted. Everything will be done according to standard. If there are any other issues that need to be addressed, they will be addressed. But the most important thing that I want to tell you, that once you see this in your neighborhood, you will want one. It enhances the value of the properties. Every property that I've seen, it does, honestly. No, man. I guarantee.
We're dealing with this property, not an advertisement for the
No,
pergola,
it's not
sir.
an advertisement. No, I'm sorry, I'm sincere. I'm very sincere. I'm telling you that it gives the utility of your property a complete turbocharge, a boost. So pardon me for taking too long, but the variances are granted, the variances expired. I'm simply asking that the variances be granted again so that we can build this beautiful property for this beautiful lady who's lost her father. That's all
Thank you.
I've got to say.
And the board chair recognizes that the variances have been granted in the past. However, considering there's so many new members of this board, I think it's probably judicious to hear arguments again. So I asked the applicant to make its presentation on this matter.
Me?
Do you have anything else to add?
Really, no. I'm gonna be honest. I just came up.
I understand.
I can't really deal with this. I'm sorry. I've
Should there have been a
waited a year and a
continuance?
half, almost, it'll be 2 years. If I could just say one thing. This thing was 90% up. And Mr. Guy asked me to take it down. I did. I conformed. I did everything he asked me within the 5 days. I've been paying for storage for it's almost 2 years to store this. I mean, this is so unfair to me. I'm sorry, but I'm just asking if you could just give me the variance that you did before so I can build it now. Because I've conformed and I've done everything Mr. Guy asked me. The wind loads, everything he wanted. There's nothing more I can do.
We have our own. yeah, we have our own discussion following the presentation.
Right.
Yeah.
Mr. Chair, if you want to continue the matter, you may, that's within this board's discretion.
Can I ask a question?
Yes.
Is there anything that prevents us from just making a motion and voting on it now?
No, not really.
The evidence in the record would consist of the testimony you've heard today and the application, and staff's presentation. So yes, you could make a motion.
I would like to make one correction. I believe this is needed for this lady because of the sun. She's allergic to the sun. However, I think that if we start putting these up all over Ocean Ridge, we will change the whole character of Ocean Ridge. And the neighbors are gonna have to look at these structures with no defense against them.
I have something to say. First of all, any variance is only for that, doesn't set precedent for other properties. It's just the way variances are set. So it doesn't mean anybody else that would want to do one would have to apply for a variance and would have to show hardship. And would, I've read this 5 times because I wanted to be thoroughly, and that's just my nature, be thoroughly knowledgeable about the situation. Number one, I think there's an issue that we're having, and this isn't just this property, where variances are expiring and after they're already been granted. And I think that was a cause from other people, that's besides the point. But they have to go through this whole process again, strictly for a renewal of a variance because of an expiration date. That's very onerous to whoever the person is. That's number one. Number two, in my view of this, the hardships are there. The house was set too far back, not her fault at all, which is one of the criteria. The owner didn't cause this situation. She has a lot of sun back there, and ultimately, and this is just me, 2 feet of a balcony. Lastly, both of these were granted. It's not like we're reviewing this for the first time. Had we, I might look at it completely different, but after they're granted, I saw the hardship. It's not a precedent for other properties. We can't even judge this based on precedent for other properties. It has to be judged on an individual basis, period. And as of that, I can see where this is a challenge for the owner, and ultimately nothing she could do about it but try to preserve her lifestyle on the property.
Does staff have any final comments to make?
No, sir, I have nothing to add.
Do members of the board have any questions for the staff, the applicant, or anyone who has spoken on this item?
I'm sorry, I have one quick question. Has anything changed in this situation since the initial granting of both variances?
No, sir, not that I'm aware of.
Okay, thank you.
And a point of clarification, I believe the town manager, speaking to your question on the variances running out early, I think they have the discretion to increase.
For 6 months.
For 6 months, right. And I think that was applied in this case.
I believe so, yes.
Yes, so this is a year since it was granted. Okay. I now declare this quasi judicial hearing closed. We will now proceed with comments and deliberation by the board. Any other comments?
I support both of this, especially if they've been already approved one time. She has already gone through the whole process. But what's really important to me is the neighbor. From what I remember last time, she had letter from every neighbor.
Correct.
Who actually liked this. And what I think what we are here for, to look after the interest of the neighbors as well as property owner. And it looks like nobody had any problem with this. So I would fully support it.
Correct. Just to bring attention, one of the considerations we had at last time, and we did approve the variance, was the consideration of the views of the neighbors and the posts that support the trellis. We determined was literally insignificant.
Absolutely.
Less diameter than a tree would be. So, would someone like to make a motion on this item?
Mr. Chair, one quick thing I'd just like to point out, when the trellis was approved last time, the board did require, as part of that approval condition, that what has been proposed can be installed, can be repaired, and can be replaced, but that it cannot be reconfigured.
That's right, no
Just as
sides, no
proposed.
sides, no electric, yes. Well, I would make that part of the motion.
Correct. That's why I was just bringing that up, if you wanted to approve it with those same conditions as last time.
Chrissy, I do have one question. Are these separate entities since there's two variances here? Would they have two separate motions?
No.
No, they're intertwined directly since it's installed to the balcony.
Is the balcony being voted on with the shield? Are we voting on both of the variances at the same time?
At the same time
I
for this one.
object to that.
Okay, you want to do them separately?
I want to do it separate.
And what's the consensus of the board?
And I will speak to that. The variance to make the balcony 4 feet was approved after the sunshine. And I really feel that a 4-foot balcony overlooking the canal is egregious to the neighbors across the way because it gives you, with no way to put up any defense. You can look right straight into the neighbor's bedrooms or living room, particularly at night, which is when I would think that the person would be doing it if they were allergic to the sun. And there is no way that they would be able to get any shield from it because you've got a waterway. You can't plant trees in the waterway. And, right,
Betty, can I address that?
I'll take care of it. Can I respond to that?
Sure.
So where the balcony is located, given that it's such a small setback, is I can't imagine how anybody on that balcony could look into any neighbor's building. Let me finish. And secondly, is that the balcony at the larger size was constructed at the house. So one of two things happened, and I don't know what it is. Either the house was approved with the 4-foot balcony, or the contractor did it on their own. I doubt if you stood there and said, oh, I want my balcony 2 feet bigger. And so therefore, I don't know the exact language, but it was outside of the owner's control. So I, for one, will support the extension of the balcony.
There was an issue that the plans were submitted with the extended balcony. The variance was approved. However, when permitting came to pass, it wasn't apparent from the initial drawings that the balcony had been enlarged, so it had to come back for a second variance. And ultimately, that was approved as well. Right. So,
the balcony was, and I spoke to it at the time, the balcony was initially 2 feet. And I maintained that 2 feet was enough to put 2 chairs and a table out there. If they really wanted to sit on a 4-foot balcony, it's a large balcony. And the higher you are, the better perspective you have. And I'm not, eventually this will become a problem, maybe not in this particular case, but if you allow people to extend balconies way out over in their property, you're gonna have neighbors fighting with one another.
just a comment, Betty, disagree. I don't think 4-foot balcony is an excessive balcony. In fact, I think a 2-foot balcony is somewhat ridiculous.
Well, I think the 2-foot balcony was just an architect's
Exactly.
point.
Yeah.
But
It's not usable. It's not a usable space. But I don't think a 4-foot balcony is excessive and as such was approved at last meeting. If you would like to, I don't know. I think because it's done, I think we should have proven together, to be honest with you. Would someone like to make a motion to that end?
I'm happy to make the motion. I don't know what the exact protocol is. I just simply think I make a motion to
You can make a motion to approve both variances with the previous conditions before the trellis placed back in. That would be a suggestion.
I make a motion to approve both variances with the conditions as outlined by the attorney.
Second.
All in favor?
Aye.
Did you take roll call for this?
I can.
You can, please. Okay, for the record.
Member Z,
Aye.
Member Martell,
Yes.
Member Arceli,
Aye.
Member Hendon,
Aye.
and Member Bingham.
Nope.
I take that's approved. Kelly?
Passes 4-1.
Thank you.
Final comment? Sorry, darn, about that. It's hard to be here.
Thank you so much.
Meeting adjourned.
Oh, Mr. Chair, we do have some administrative stuff just to go over.
Oh,
The
then-
hearing's over, but we have another agenda item regarding, since we have new board members, some things we'd just like to discuss.
Sure.
And then if there's any, commissioner comments at the end. One thing that the town clerk, Kelly Avery, is passing out is a handbook that we put together that contains general information about the rules of this board in terms of sunshine law, public records law, ethics, and quasi-judicial hearings. I'll just touch on them briefly. You can review the handbook. If you have questions, please reach out to the town clerk or myself to address any questions you may have. Obviously, as most of you know, the sunshine law requires that any discussion between 2 or more board members happen in a public meeting. What that means is, outside a public meeting, 2 or more board members can't discuss an issue that will foreseeably come before you. So if you find out that someone's going to be requesting for a variance, 2 or more board members couldn't get together to discuss it prior to the public meeting. That's really important too for a quasi-judicial meeting. Everything this board does is called quasi-judicial, and what that does is it signifies that you're sitting as the judge to listen to the evidence and testimony presented in support of a variance and make a decision based on that evidence and testimony presented and the criteria in the code. And for the last hearing, the agenda item, if you read through it, contained the criteria that you look at to determine whether the variance has satisfied all of that criteria to be granted. So for a quasi-judicial hearing, it's very important to the applicant and to the town that we ensure it's a fair hearing. So everything that you know, that you talked about with someone needs to be either revealed in this hearing or displayed in this hearing. That way we won't face any kind of due process challenges, and that everybody knows what this board knows about their variance application. So the sunshine law is even more important in a quasi-judicial hearing because you want to make sure all your discussion of the variance occurs in the hearing. There's also the public records law. Now for this board, the only real communication you're going to have with the town for purposes of being board members is usually receiving the agenda or coordination with you on upcoming meetings. However, you need to be aware that if you correspond with anyone in writing about official town business as a board member or otherwise, you are creating a public record. So my recommendation in that case is always make sure that any kind of correspondence like that, you either copy the town clerk or the town manager, because all emails that come to the town manager or the town clerk are retained indefinitely on the town's email system. So if you want to make sure that the town has all your public records, just copy one of them so that it's secure in the town's records. Otherwise, you need to be very careful If you use any kind of social media, any kind of texting or kind of email on any personal devices with members of the public or otherwise, if it involves town business, you created a public record, and if the town's not copied on it, you become the custodian of that public record. So for purposes of public records requests, you would then have to provide all the public records in your possession. So just keep that in mind. The ethics rules, it goes into detail on some of the ethics rules. This board is governed by the Palm Beach County Commission on Ethics and the state Code of Ethics. The Palm Beach County Code of Ethics is usually much stricter than the state level. So for purposes of determining whether or not you have a conflict of interest or there's other ethics rules involved in something that you're doing, we typically look at the county rules first. The biggest issue that will probably come up for you as board members and granting variances is whether you may have a conflict of interest. If it's a neighbor that lives directly next to you that's asking for the variance, you're supportive or you're against it, that may create a conflict of interest for you. Every ethics situation is very fact specific. So as soon as you recognize that there may be an ethics issue, especially a conflict of interest, let us know, the town manager, town clerk, or myself, because oftentimes we have to do some research to look at the ethics rules to see if you do have a conflict of interest or you don't. If it's sort of a fact-specific one that we might have to reach out to the County Commission on Ethics, we need additional time because they usually need at least 30 days to do a formal opinion on the issue.
I have a quick question.
Yes.
So if, as far as, because it's board adjustments and variances, if something comes up, where we're, oh, sorry. If something comes up where we're directly affected by it, meaning within that 300 radius, is that something we should just recuse ourselves of and not beyond that?
It's really on a case-by-case basis. For one of the ethics requirements of this board is that every board member has to vote unless you have a conflict of interest or the appearance of a conflict of interest. Since all of your hearings are quasi-judicial, you want to even avoid the appearance of a conflict. So if you feel like it's too close to home, you can recuse yourself, but if you do that, what that means is you can't participate in the discussion and you certainly can't vote. So if you identify something like that, reach out to one of us and we can discuss it and figure out, the right steps to take. Because if you do recuse yourself, there's some additional steps we have to take to advise them of what the conflict is and file a form. But it's not that big of a deal, but just, keep your radar on when you're looking at the agenda to see if, is there a potential conflict here or something like that. Also take a look at the gift rules because now that you're on an official board, you need to be careful of gifts that you accept or receive. So take a look at those rules, and if there's any questions, give us a call. Again, it's very fact specific, who gives you the gift, what the gift is, and things like that, so we take a look at that. As I mentioned, quasi-judicial hearings is what this board does. So as we saw in the hearing, at the beginning of the hearing, there'll be a request to disclose any ex parte communications. Just keep in mind that's to keep the hearing fair for everybody. So you're free to go talk to whoever you want to before the hearing, except for each other. Keep that in mind. You can talk to the applicant, you can talk to town staff, just make sure that when we go into the hearing that you do disclose any of those communications and any instructions that you did. And again, if there's any questions you have, even at the time of the hearing where you're like, wait a minute, I just realized there might be a conflict, or, I forgot I didn't disclose this, let us know. We can always recess the meeting, discuss it, and try to figure out how to go from there.
Just a question. As you pointed out, there's been a number of cases that have been brought here that are from expired variances for whatever reasons. And they've been approved in the past. Assuming that no ordinances have changed, do we really have to revisit the whole issue once again? I mean, we do.
We do, and the reason for that is, and just to sort of maybe explain the legal process. The hearing before this board is quasi judicial. The record is established here. If someone wants to challenge your decision, they file an appeal in circuit court.
Correct.
The appeal in circuit court is to review the record that was presented to this board and determine whether or not there was substantial competent evidence to support your decision. That's the legal recourse. So the reason I bring that up is to understand that everything presented here is the record. So if we just rubber stamp a variance that was previously approved and don't at least go through the process of establishing what the record is, hearing some testimony and evidence, having the board discuss it again, if someone were to challenge your decision, the record that went up to appeal may be deficient because you didn't go back through that process. So you want to make sure that you do look at it again, and maybe it is sort of like the last hearing we had where it's pretty straightforward and it doesn't take that much time, but we still have to do it every time just to make sure there's a solid record and if your decision doesn't get reversed on appeal.
Question, is there any, sorry.
Question, how closely do we have to abide by the laws that are set down by planning and zoning in the commission? And what liberty do we have to just say, well, this would be nice?
Well, as you can see, each agenda item goes over the criteria for approving a variance. And as was discussed in the last hearing, there needs to be a hardship shown. That's the basic standard to grant a variance because you're allowing someone to do something that's not currently authorized by the code. So when you have that, someone who's objecting, and typically it's a neighbor who might be an affected party is objecting, that's when I think you need to pay much more attention to each specific criteria. Obviously, in each hearing, you want to pay attention to the criteria, but when you have competing interests that are clearly presented to this board, and you would usually see that with the applicant and then another affected property owner who they disagree on whether or not the variance should be granted, that's when you really need to start taking a really hard look at each of the criteria to make sure that there's evidence presented in the hearing to support each of the criteria. I recommend doing that for all variances anyways, just so you have a solid record on appeal. Some variances, I would say the evidence isn't as strong as it may be to support your opinion. When you have things like all the neighbors are in favor of it, you know, you believe that there is a hardship there, you may not go as in depth to all of the criteria.
I have a two-part question. Number one, is the 6 months set in stone as opposed to, because 6 months in Florida with builders can be pretty quick.
Correct.
You know what I mean? I mean, is there a way to make it 12 months with a 6-month extension by the town manager instead of 6? Because 6 is tough sometimes, depending on, you know, something, a fire pit you can do, right?
Right.
Or a trellis or something where you need some engineering drawings, sometimes that could take a lot longer than that. And getting contractors to your houses even is a big deal sometimes, and I can see where these could expire. I know that town manager is allowed to get another 6-month extension, but I'm just wondering, is that set in the ordinances or it's 6 months?
It's in the ordinance, and if this board wanted to, you could make a recommendation. You can, obviously you're allowed to talk to each of the town commissioners and let them know that you think the ordinance should be changed to increase the time frame for the variance. That's certainly an option.
Second part of the question was, because I was here last Board of Adjustments meeting where this, you know, this one hasn't come up yet. How much stock do we take in people that are coming here to object that aren't affected by it?
That's a good question. If they're just coming to generally comment on whether or not the variance should be granted, and they're not an affected party, when I say affected party, it's typically that 300-foot radius where they can show some direct impact that what the applicant is seeking is going to have on them. If it's just someone generally from the community that's making public comment on them, their testimony doesn't have as much weight as the affected party, but this board, you're really sitting as the finder of fact, and so you decide how much weight to give someone from the general public. Keep in mind too that we often allow public comment. And if someone's just making a general public comment and they're not under oath, technically you can't consider that because it's not considered evidence. It's just public comment. If they are under oath and they make a general comment, it depends on you how much weight you want to give that.
I have a question, excuse me, regarding the records. Is that possible for the one just today? Because the record was there. Can the board make a motion to supplement today's record with the prior record? So just in case of any lawsuit, they can be part of this record?
The only legal issue with that, you can make any motion that you want. The only legal issue with that is if there is someone here that's objecting to the variance currently before you who wasn't involved in that prior hearing, they now wouldn't have the opportunity to know what that prior record may have stated. So what I would recommend in that case is we as staff can make sure that if it's a variance is coming back because it expired or what have you, that we will make the prior record part of the record and part of the backup. That way, everybody who comes to the hearing will have full access and it could be part of the record. So if that issue comes up later, there will be the initial hearing record as part of the new hearing record.
Okay.
A question, I might, I'm trying to get the exact wording, but there's like A through G of all the items.
The
Criteria. So from a legal perspective, in order for us to approve, are we taking the position that every criteria has been met?
Yes.
And so then if an attorney stands up and says, well, you didn't meet 3 criteria, I guess our choice is just we may feel it does, and then we can approve it, but knowing that they may very well, I don't know what is their next appeal to the commission and then file a lawsuit?
To the state.
Goes to circuit court. They would appeal the record to circuit court. So what you can do is during the hearing is if you look at the criteria, you just want to make sure there's testimony or evidence to support each of the criteria. So typically in the application, we require the applicant to provide some justification for each of the criteria, and that application is part of the record. Staff will also do an analysis and will have information on each of the criteria as well. That's always part of the record. Then the testimony that you hear from the applicant's contractor, that's all supporting it. And if you believe that evidence and testimony is substantial and competent, meaning it basically supports each of the criteria, then yes, you can approve it. If an attorney gets up for an affected party and says he or she doesn't believe that they've met that standard, they need to provide substantial competent evidence showing that those criteria have not been met. Because you would also need that type of criteria or that type of evidence to show, oh, the criteria hasn't been met because of X, Y, and Z. Statements by attorney is not testimony, it's not evidence, it's just argument. So you can listen to it, but of course, as the judges of the matter, you can decide, well, I believe that there is evidence to support this.
So what you're saying is the burden of proof would be on them if they said that they didn't meet a criteria.
There always has to be substantial competent evidence to support granting or denying a variance. And if all you hear is evidence in support of all of the criteria, then that kind of drives the decision. It's when you have alternating substantial competent evidence for and against the criteria where it becomes a tougher decision.
Christie?
What?
Excuse me, can you explain denying without prejudice versus denying with prejudice?
Yes. So when you make your decision, obviously you can approve it, straightforward approval, approve with conditions. You can deny it, and when you deny it, you can deny it with or without prejudice. If you deny it with prejudice, what that means is, I believe under the code, the applicant cannot come back and seek the same variance. I believe it's a year.
For 1 year.
They have to wait for 1 year. If you deny it without prejudice,
they can come back and say modify their variance or change their application and bring it back before you sooner than that 1-year timeframe. And we did that before in a previous hearing where we denied without prejudice because we believed that some of the variances had a hardship, other variants did not. So it was to give the applicant an opportunity to revise the petition and come back.
One other question has to do with the staff recommendation, because I know some other municipality, the staff actually look at it and they do make a recommendation of approval or disapproval. But here I notice the comment is the staff provide information, but they do not make any kind of recommendation. Is that the reason for it, not having a recommendation coming from the staff?
Can I make a statement? They used to give a recommendation,
Now it's pretty much a template.
and now they haven't done it. But they gave a recommendation and why they approved or disapproved it.
To answer your question, the recommendation wanted to take into consideration if there was any additional testimony at the meeting. There have been other cases, like the one the town attorney mentioned, where the board approved some of the variances without prejudice because there was clearly none of the criteria were met in that particular case. And it was very clear from a staff perspective that a recommendation was necessary.
I can also say from a legal perspective that we have to be kind of cautious in how we do our staff report. Because if in our staff report, we have a recommendation, say for denial, and this board approves it, if I'm an affected party's attorney, then on appeal, I'm gonna argue staff's own, or the town's own staff recommended denial because they didn't believe the criteria was met. And it kind of creates an inconsistency. So when it's kind of a close call, town staff usually doesn't take a position on it so that we don't create an inconsistency in the record. If, when we look at it with the town manager and we feel like they haven't really met any of the criteria, that's when we might take a stronger position with it. But we have to be careful because we don't want to create an inconsistency for this board so that your decision gets reversed on appeal.
Well, speaking of inconsistencies, what happens if a variance has been approved and then it comes back because it expires and then you disapprove it? How's that for an inconsistency?
Well, as Dr. Martell pointed out, each variance stands on its own 2 legs. And since
But it's really the same variance.
I agree. Now, if additional facts and circumstances came to light, and their affected party showed up to challenge it, there could certainly be different facts and circumstances that may dictate that this board say, you know what, this time we're not gonna grant it. So that's why we gotta look at each one of them and make sure that, we give it the attention it deserves so that we kind of protect ourselves from an appeal.
I think that's a good point, because I think the inconsistency there, it's twofold. Number one, for example, today, if all of a sudden, we had letters from everyone last time, but all of a sudden, 4 neighbors are objecting to it now. I mean, that makes it significantly different.
I had some neighbors come to me and say they signed that only because they were neighbors and they didn't necessarily want to go all over.
Right.
So, I mean, that plays 2 ways.
Well, it does, but it's now it's not a matter of public record, so it's a whole other issue. So having gone there though, what about does anybody have any objections about change or giving a recommendation? You're going from 6 months to 12? You know what I mean? Because it seems like an expiration, 6 months is.
Well, I don't know if it's only been recently that this has started to occur, where variance has been expired. I don't know if it has to do with town staffing in the past or a changeover, or if this is a blip, or do we really have to change the ordinance to extend because of circumstances in the community? Maybe it is harder to get engineers and contractors and people on site, and maybe 6 months is not reasonable any longer. I don't know that answer.
Are there any towns that have different?
What you can do is when you grant a variance, you can state what you want the time frame to be. That's another way to address it. So for your conditions, depending on where they perhaps are in the process of developing plans to construct the variance, you could provide them additional time in the conditions to say, allow them 12 months from the date of approval to construct whatever it is that they're seeking to do. You could do that as well. It really is almost a case-by-case basis, because we do know that there's supply chain issues that people are still affected by, and construction timeframes people are still affected by. But sometimes a variance comes to you because they did something without building permits. So they are really behind the curve in terms of now they've got to start the whole process of getting, drawings and engineering and all that together. Other times you have people that have submitted for a building permit and the building official says, this isn't allowed, you need a variance, and then they come here and they already have their building plans ready to go, except for, they didn't realize this needs a variance. So it kind of varies. It's up to you. We are at the town commission level. They are considering, I believe is it second reading or first reading? Second reading, to extend, we have a local duration of construction. And right now they're extending that, I think, through January of 25 to recognize supply chain issues and construction delays. So you could make the recommendation to change the code, or you could just keep it in mind at each variance once you understand the facts and circumstances and whether you approve it with additional time to be constructed.
That might be a better idea to do it that way.
The other, we had the opposite problem some years back. People were just taking enormous lengths of time to do construction, and that was creating other problems. So, everything got tightened up. Now we're letting it mind again. So, like I say.
The code was written because they want to keep neighborhoods quiet and get things over with quickly. And I think you have to look at each one of these situations separately.
Anything else?
We're trying to keep Ocean Ridge small, quiet, open.
I have a question regarding the variance. Are those variants that they're given are permanent? Because I'm kind of a little bit here, because we just give a variance to setback for a new construction. And the construction obviously is going to take several years. But unless if you put condition on it, this variance is going to be, even if they, let's say they demolish the house and they put another one, that variance still stays, or that's gone?
The variance, if it's approved with conditions, the variance with those conditions run with the land. So that's why it's good to think about those issues when you're granting a variance in terms of, like the last hearing we had, what if the trellis gets damaged, they need to replace it? We're fine with them replacing it, but if they reconfigure it and make it bigger or something like that, that's a different story, then they'd have to come back for another variance. Those types of issues you need to keep in mind because, for example, we granted a variance recently for a lot size and lot width. That variance would run with the land. So if the house gets destroyed and they want to reconstruct, they would still have that variance. But in that one, they met all the other requirements of the code. So really all you're doing is allowing them to reconstruct, redeveloped, consistent with everything else in the code.
But you could put limitations on variances.
Yeah.
It's only for this, if some catastrophe happened, the variance would expire.
Especially if there are variances, they're going to set a precedent. I would think that maybe there should be some kind of time on it, so that way it's not going to issue a problem later on when you're not giving a variance to someone else, and they're going to have it go with the land, permit.
But typically, it's not a precedent. It's an individual basis.
Right, it's on a
It is,
case
but
by case
it's
basis.
exactly the same case. It is still,
They'll certainly argue that to you.
it creates really a problem if it's exact case.
No, absolutely.
Deny it versus someone else. You got to be really good reason.
Anything else, Christie?
Nothing further unless you have further questions.
No, I have something of the board. It's our prerogative on the date and time that we meet. We typically meet on Wednesdays at 9 o'clock. At one point, we did meet earlier, we moved it to 9 o'clock. I just, because they're new board members, is it convenient for you at time? Or is there a better day or
Great for me.
great for you?
Mine's fine.
Good.
8 to
And Wednesdays are, at Wednesday.
But she has to bring cookies.
Yeah.
But it's not just Wednesday, it's the-
I don't know if you
It's the
could
third
write that
Wednesday
into
of the
it.
month. It's always the third Wednesday.
Third Wednesday, that's correct.
No, 9 o'clock.
Art,
Yeah, that's fine. I just.
I'm alternate.
you're good, okay.
Uh,
So we'll keep it at Wednesdays at 9 o'clock. And
When is the variance going to come up on this other property?
June,
The June meeting.
Huh?
June.
What date?
It'll be the June 21st meeting.
I won't be here.
I won't be.
yeah, you know, summer is a problem.
That should be your next discussion.
Yeah, and there was gonna be an issue, you know, the one thing, you know, when homeowners want variances, you know, on the one hand, from their side, it's not fair to necessarily have to wait months and months and months to get a meeting of the board. On the other hand, you have the realistic issue that we have to convene the quorum, and that's one of the reasons we have alternates. But certainly, June, July, August, I would think is tough.
Could we move it up to earlier in June?
Are we limited to once a month? Is that part of the, or can you, because of the continuance, you can actually convene more than that?
Are you talking about the Throwers variance?
Yeah,
Because they're out of town. Ideally, if you could push it to the fall.
no, I'm talking about in general, if you are asking for continuance or something, can you actually do it as a special meeting or you have to wait on a monthly basis? Because I'm just,
There's currently a requirement in the code that once the application is deemed complete and we start our review, it has to be heard within 60 days. So they can request a continuance, but oftentimes that just gives them enough time to the next meeting.
60 days.
So it's 60 days in the current code. That's another issue, that if you felt that that was restrictive and you wanted to allow for this board to have special meetings or things like that, we could make that change to the code. Just keep in mind a couple things. Obviously, anytime a board does a special meeting, it takes staff time to have to reach out to each of you and set that up. We also have to obviously coordinate with the applicant, the town planner, myself, to make sure that we're all available.
And I think there has to be some public recordings.
And we do have public advertising notice requirements that we have to do. So every time there's a continuance or every time we set up a special meeting, all of that kind of gets thrown into whack. So we do try to keep it a standard meeting time, so that, we can meet that 60-day requirement. If it's the desire of this board not to meet, like say in a couple months during the summer, we would just have to advise applicants that we can't even take in their application until we know that there's an upcoming board meeting that we could make that 60-day requirement. So that's why we, just have them every month. Sometimes, we've had several of them lately. Before that, we would go months without a variance hearing. So it really just kind of depends.
I think the challenge is also that you have this, and you said it succinctly, sometimes it puts a burden on the person if you have to make them wait 2 months, 3 months, first of all, on one side of it, we're complaining that the construction's not getting done quick enough. And then on the other side, well, I'm not here. Terry Brown, I have to say, a few months ago, had a great comment, and it was, if you can't be here, that's why we have alternates. And if in that combination, then maybe that person shouldn't be on the board. Like, for example, if you leave from June to September, that's a problem, because maybe that's not a position you should be held at, because obviously we're trying to keep these people, their construction going. But we have alternates, so it's hopefully we don't run into that challenge, but we might sometime.
I have a question. If there's an alternate, can you pass off the research that you've done on the project to the alternate?
That's interesting. Yeah, I don't know.
All right, so I'm gonna
Because it's
tell
maybe
you
a violation of some
I'm gonna tell you the technical answer, and then I'm gonna tell you why I would recommend against that process. From a technical standpoint, the Sunshine Law prohibits you from having a discussion with another board member outside a public meeting. However, you can tell a board member how you feel about an issue, and as long as that board member does not respond, there's no Sunshine Law violation. So if you were to pass on your email and Google research to an alternate and say, here's what I found, and that alternate doesn't respond, technically it's not a Sunshine Law violation.
Because that conversation.
But I'm telling you that from a very technical standpoint. You will create the appearance of a Sunshine Law violation if you email another board member about an upcoming meeting, or you're seen talking with them. It'll create the appearance, and oftentimes as your attorney, it's the appearance I have to fight against more than an actual violation. So by technically not a violation, I don't recommend it, and what I recommend is give that information to the town manager or town clerk or myself, and we will make it available to the entire board in an email and say, do not reply all to this email.
Do the alternates get a packet automatically though on every meeting?
Yes, they do.
Okay, great.
Okay.
Would it be too onerous if we asked that the ordinance be changed from extensions every 60 days to make it a 90-day or 120-day extension for the months of June, July, August, or something along that line? And that way it doesn't say we're not going to meet, but it gives the applicant the opportunity, for instance, if people are out of town themselves, that they don't have to return here within
because
60 days.
the owner might be seasonal.
Yeah,
That's
exactly.
a really good point, yeah. Is that something that would have to go from us as a recommendation to the commission, and then they would?
And then they can decide if they want to pursue changing the ordinance to address that.
Do you need that in a motion?
That would be great.
Okay, so I move that the ordinance be changed, that extensions granted for the Board of Adjustments remain at 60 days, however, extended to 120 days during the months of June, July, August,
That's for a continuance.
for continuance.
I'll second that motion.
Okay, seconded.
Can I ask a question? Just to clarify, should that be, would that also, I'm just saying, if, for example, if the meeting is May, since that extends, so would it be continuances granted at meetings in May, June, July, August? So it's, because if it's just for June, that means, for example, if someone was heard in the April meeting and 60 days takes them to June, maybe people aren't around. So I think that I'm suggesting that the dates go from the date of the meeting when it's first heard, as opposed to just specifying June, July, or August. Just a thought.
I believe,
We're saying the same thing.
yeah,
I'm
it's
just trying to make
60
sure the
days.
language
Yeah,
is
yeah.
They
correct.
can request a continuance 60 days from the date of the first hearing. So maybe what the best thing to do would be to have it allow up to a continuance of 120 days and not tie it to specific months. Because if the applicant perhaps wants longer for some reason, that would maybe give the board a little bit more wiggle room.
That makes sense.
And this way it puts it back on the applicant, not necessarily, we're not meeting their needs.
Right.
But gives them more.
And it
leeway.
gives us the right to do it if it's going to be over a summer period.
I have a question for that. So does that need to be brought to the commission as an ordinance change, or can we just say, listen, based on this individual, just like you said, on an individual basis, on a variance by variance meeting, if the person says, can you give me 120 days? Can we say yes, and then just skip the, bring it to the commission and going through two readings and things like that?
Let me look at the ordinance closer on that issue because I'm not sure offhand. I think the 60 days is in the ordinance from the hearing date, and that limits the ability to do the continuance. But I'll need to look at it, but I'm assuming that the preference of this board is to allow for more time for a continuance, either at the board's discretion or the applicant's discretion.
Correct.
Okay, so is the motion then to change the ordinance or address the issue to allow for a greater than 60-day continuance at the request of the applicant or by the board's discretion.
Yeah, I think that makes more sense.
Yeah, I believe maybe there's no need for it. When we do continue it, at that hearing, can you say continue for up to 120 days?
Yeah, listen, perhaps what I should do is let me look at the ordinance really quick. I think I understand what you want to do. I'll research it. If we need to make an ordinance change, I will then make the recommendation or your recommendation to the town commission to make that ordinance change. Or I will send out an email to the entire board as to how we can address it in a meeting. But oftentimes, I think what happens is the applicant requests a continuance, so it's taken off the agenda. So we need to figure out, between staff, this board, and the applicant, how we could sort of make it work out so that we could consider those continuances and make it work so that it works in everybody's best interest.
Right. It has to work both sides.
That begs the question, then, if we're making a recommendation to the commission, if we talk to one of the commissioners, is that a violation of sunshine because we're making a recommendation to the commission?
No, as long as you're not talking to another member on this board about an issue that will foreseeably come before this board, you're able to talk to town commissions, even if you make a recommendation on something. You're allowed to talk to planning and zoning members as well, even if you've heard an issue that's coming to them before development, because you are on separate boards. So the sunshine law only applies to your board. But you do bring up an interesting issue, and just keep in mind, if you ever decide to go before the town commission on an issue that you heard, I recommend that you clarify whether you're speaking as a private resident, or if this board gives someone the ability to go before the town commission saying, here's why we did this, to just clarify what position you're taking when you're speaking to the town commission.
Good, thank you.
Okay, but before we take a vote on that issue, let me do a little bit more research and see if there's a way we can do it without changing the ordinance. But if we have to change the ordinance, we'll reach out and make sure you're good with the recommendation to change the ordinance to give you 120 days discretion.
Right, before we adjourn, I think we have an issue that's coming up, because it sounds like, Carolyn, that the throwers can't be here, and they're supposed to have a
That's what I
June meeting.
mentioned, yeah.
Yeah, is that gonna be an issue because we haven't finalized this vote on this thing?
I mean, right now, under the code, they have to come to the June meeting.
Right.
They told me they would be there.
Can they,
Okay.
can they come to the meeting and request another continuance?
I believe, I'll have to look at the code on that. I just know we're under a 60-day requirement. So if they came to the June hearing and requested a continuance, that's a separate issue. I don't really like to do that because oftentimes if there's affected parties, the affected party goes to the time and trouble of showing up. So we usually like to know if there's a continuance to know before the hearing so we can let everybody know, don't show up.
So just for clarification, if we change this prior to the June meeting, how does that affect continuances in progress now?
That's what we'll have to look at.
Okay.
Yeah, I gotta sit down and look at that code from the different angles and see
Okay,
how we can try to make it work and make it more reasonable for everybody.
perfect. Any other issues? Thank you all for your time, and adjourned.